Thank you very much. For those of you who don't know me, my name is Anna Myers, and I'm the Executive Director of the Whistleblowing International Network. And I thought I'd maybe, for some of you, give you a tiny background on actually the Whistleblowing Monitor and how it started. It was an assistant at WIN who worked with us a few years ago who suggested that this online tracker he had studied at university might be helpful to us. And it was in the context of his politics degree, and it was set up to track how many of the 353 promises that Justin Trudeau had made in the run-up to the Canadian elections, his first running for prime minister, that he actually kept once he became prime minister. So as a Canadian, this appealed to me on that level, but really it was something we jumped on because we believed that we needed to maintain momentum on the EU directive after it was adopted. You know that often donors think things are all done once the EU directive has been adopted, and focus tends to shift. But we knew that that transposition was the beginning of a new story, and we were also in the middle of the COVID pandemic. So we wanted to really provide a focus for civil society engagement through that period. And I'm incredibly pleased to announce and to let you know it's the only source of publicly reliable information on transposition. The monitor is followed by the European Commission, legislators, lawyers, and compliance officers, many of whom are also among the 4,000 plus followers that WIN has on LinkedIn. And in the last 12 months to November 30th, 2023, the monitor was visited by 20,000 users in 48,000 sessions. So it really has been a useful tool, but it's also been something that we hope to develop, and it's been mostly run in the last few years by Ida Nauers, who I'll be introducing in a moment. But next year, just to let you know, we hope to be developing the national pages on the monitor, and we will be doing this to better track compliance with the directive, as well, I hope, with a little bit of the international best practices principles that are out there. And we're also very happy to welcome the work of the National European Integrity and Whistleblowing Authorities, NEWA, who are set themselves up, and you'll be hearing from one of their co-chairs later, as a network, and having an information page there on their work on the monitor as well. So that's terrific. One of the things I thought I'd give you a little bit of update on is that the Council of Europe's Parliamentary Assembly, so to just move a little bit outside the EU, their Committee on Legal Affairs and Human Rights is continuing to monitor whistleblower protection across its 47 member states. Many of you'll remember Peter Omsic, who led their work from 2010, and that was followed up by Sylvain Wasserman later in 2019. Both Jean-Philippe Fogel, who unfortunately isn't here today, he's not well, but he and I both gave evidence to a hearing the committee held in Paris earlier this month. And the new rapporteur is an MP from Lithuania. So he's very keen to push the agenda further, particularly in Central and Eastern European states, where I guess, the issue of whistleblowing is much better understood than it was, but they still struggle with the concept of whistleblowing. And I really welcome the committee's continued interest in oversight and advocacy in this area. We all know that transposition is just a start, and we know that where countries do not really understand or don't even want to adopt whistleblower protections, they will do the least possible, and in so doing can drop below minimum standards. And in some countries, we're very pleased that they've used it as an opportunity to clarify and perhaps improve certain aspects of their laws, but these examples are rarer than we would like. So this seminar has been put together to help all of us understand where we are right now and confirm, I hope, our collective commitment to keeping the pressure high on national governments to do better by whistleblowers across Europe, supporting the hard work of our national membership organizations, monitor country editors, and our other partners, and perhaps to keep a little bit of pressure too on the European Commission to really hold member states to their commitments under the EU directive as well. So we've got our work cut out for us, and this seminar will enlighten us further on what we need to focus on. I may not have a chance to thank her later, but I really want to thank Ida Nauers, the EU Whistleblowing Monitor Law and Advocacy Manager, for putting this impressive lineup together for you this afternoon. I know it's a bit like herding cats and getting this all done before we break for the holidays. And she's just been doing terrific work in this space. And to also Dr. Simon Gerdman at the University of Göttingen for agreeing to co-host it with us. So I'm now going to hand over to Ida to moderate as well as to contribute to this afternoon's seminar. I'll be listening with great interest, and over to you, Ida.
Thank you so much and welcome everyone. I'm very pleased to see so many new faces and well-known faces. Hope you're having a good afternoon. And as Anna said, I'm Ida Nowers. I have been Law and Advocacy Manager of the EU Whistleblowing Monitor, of which I put a link in the chat. And I have the privilege of being your moderator for today's session. As we delve into the important topics to better understand the current landscape of whistleblower protection, we are delighted and honoured to have a distinguished lineup of speakers who will share their insights, experiences and analysis. I'd like to extend a very warm welcome to our speakers and to you all for joining us. Your presence is vital as we navigate through the progress and the challenges in the implementation of the EU Directive on Whistleblowing. So over the next hour and a half or so, we'll hear from our speakers who really have been at the forefront of shaping the whistleblower protection laws, evaluating the legal consequences, and advocating for enhanced standards. As we proceed, I encourage you to actively engage in the discussion. Please feel free to use the chat function to share your thoughts, ask questions, and contribute to this conversation. I will be reviewing the chat regularly and posting your questions to speakers at the Q&A session at the end. So our distinguished speakers for today, as outlined in the agenda, which you should also find in the chat, I will introduce in order now. Firstly, we have Dr. Vigilenza Abazi presenting on the EU's role in transposition and implementation oversight. Vigilenza is a legal scholar renowned for her expertise in whistleblowing. She is co-founder and executive director of the European Whistleblowing Institute. Her biography is very long and impressive, so I've selected just a few highlights, which include co-drafting the model EU whistleblowing law for the European Parliament, co-authoring reports for the Council of Europe, and overseeing the compliance monitoring for the European Commission. Secondly, we have Dr. Simon Gerdemann, who will update us on the legal consequences for transposition failures. Simon is also a legal scholar and the principal investigator of the German Research Foundation's project Impact Analysis of German and European Whistleblowing Law at the University of Göttingen in Germany. He is also co-hosting this event, so we thank him very much. He's also a well-recognised voice on the topic of whistleblowing legislation and has advised the European and German legislators on drafting of new whistleblowing laws, supported whistleblowers and whistleblowing NGOs in the field. Next, we have Marie-Therese Cole, who is the Whistleblower Protection Lead at Transparency International. She leads TI's policy work on whistleblowing and coordinates the movement's advocacy efforts to improve the protection of whistleblowers in Europe and across the world. Marie has authored and contributed to many of the well-known whistleblowing standards, policy papers and reports. Today, she will be discussing the EU minimum standards and practices and presenting TI's latest findings, analysing the EU countries' approach to transposition. Thank you very much for joining us as well, Marie. Next, we are delighted to have Zuzana Douglasova, who is President of the Whistleblower Protection Office in Slovakia and Vice Chair of the Network of European Integrity and Whistleblowing Authorities that we now call NEWA. Zuzana's equally impressive biography, including working as a lawyer at the European Court of Human Rights in Strasbourg. Zuzana will be giving us an update on NEWA and the enhanced role of competent authorities under new EU frameworks. Thank you for your time today, Zuzana. Next, we're very pleased to be joined by Cosmas Sittel, who is Managing Director of Whistleblowers Network in Germany. He has, amongst other things, been an invited expert in the public hearing and the legal committee on the German whistleblowing law. And we are very interested to hear more about the official complaint Whistleblowers Network have submitted even to the European Commission on the failures or weaker points of the transposition law. Next, we are pleased to be joined by Jan Dupac, who is senior lawyer at Transparency International Czech Republic. Jan will be updating us on some of the very interesting cases in the country which have already been testing the new transposition legislation, and we hope to hear what these cases can mean for how we understand both the opportunities and limitations of this new wave of whistleblowing laws. Thank you, Jan. And as Anna mentioned, unfortunately, we won't be hearing today from who was supposed to be our final speaker, Jean-Philippe Vogel. He's had to pull out unfortunately, due to ill health. We were hoping to hear an overview about the French transposition legislation, sometimes referred to as the Wasserman Law. We hope to circulate to speakers any resources or presentation he's able to share with us. So as you can see, we have a very packed schedule, quite tight session. Hopefully we can stay on track and leave time for questions and answers at the end. So for a quick state of play from me, we're now approaching 4 years since the European Union Directive on Whistleblowing was adopted, and that's then 2 years anniversary of the official deadline for all 27 member states to transpose this directive into their national legal systems. The EU Whistleblowing Monitor was established to track transposition, and I'm delighted to announce that we very much hope to continue to develop the monitor in the future to monitor implementation, cases, legal reforms ongoing. So currently 25 member states have adopted transposition law. Poland and Estonia are still listed as in progress. They both have draft proposals under consideration. Progress generally has faced significant delays, with only 8 countries meeting the official deadline and a further 8 countries having since been referred to the European Court of Justice for those delays and potentially incurring substantial fines. The process has been often quite convoluted, with some apparent hesitation and confusion of policymakers. Amendments have been made in some countries fairly imminently after legislation has been adopted. The monitor has not categorized any countries so far as transposed, and WIN maintains that none of the new laws actually meet the minimum best practice standards, or sorry, the minimum standards of the directive, based on the analysis of our partners and experts. This position is so far supported by 2 new reports analysing these transposition laws, one of which we'll hear more about from Marie shortly. So, thank you very much all again for being here. Without any further ado, let's commence with our first session. Dr. Vigilenza Abazi, the floor is yours.
Good afternoon, everyone. Thank you very much, Anna, and in particular, thanks to Ida for organizing this excellent and incredibly timely event. Indeed, it's sort of December is very important, not only that it marks 2 years since the transposition, but in terms of everything also that is politically happening across the Union. And I will start even from the Netherlands, where I'm joining you from, where in the one hand, we have Omtzigt, who was the rapporteur with the Council of Europe as potentially maybe even leading a future government. But increasingly, we see sort of governments that potentially are very hostile to the idea of whistleblowing and to the protections of whistleblowers. So before I delve into the legal context of what the oversight issues are, both in terms of interpretation and enforcement, I do want to say that part of the challenge right now is even sort of the will. So it's not just a matter of legal definitions to what extent whistleblowing actually in Europe right now, in a way, ironically, potentially is even more at center stage of being attacked or reduced of protections rather than what the directive does intend, which is to increase protections. I would like to sort of, if there's one main takeaway that you can have from my short here 10-minute intervention, is sort of to say a whistleblower law of bits and pieces, which in a way, ironically, is contrary to the very purpose and objective of the directive, which was meant to more unify or create a higher standards across the European Union. What we see today is the opposite of that. There's generally, I can only echo what Ida also said. It's very clear at this point in time that almost no single member state has either adequately or fully transposed the directive. Now, let me sort of explain a little bit, especially since many of you maybe don't have the sort of European law context background. So in that sense, let me sort of elaborate what the Commission's role is, particularly from an institutional perspective in ensuring oversight and enforcement. Right now, and potentially many of you already know this, the Commission is already gathering data in terms of what the transposition has been looking like. And that takes place in a 2-step process. The first part of the analysis is simply making sure that each provision of the directive is actually being transposed into national law, so that there's no aspect of the directive left uncovered by national law. And that in of itself is actually difficult exercise to do, because many member states have not merely have one single law in terms of the national transposition of the directive as a single bill that can be read, but actually many of them have sort of different, dividing it into sectors or dividing issues. And sort of it is a big exercise to merely even first see the overview of whether everything has been transposed. The second then step is to see whether those national provisions actually stipulate, meet the requirement of the minimum standards or potentially even go higher. And especially important is that those provisions nationally do not in a way reduce potentially higher protections that may have existed at the national context, which would be against Article 25 of the directive, speaking of the non-regression, meaning that the member states shouldn't use the opportunity, the timing of amendment of national laws to regress. And that, for example, was a moment we saw in Ireland, where initially the initial proposals were in a way decreasing some of the protections that Ireland had already more highly stipulated. And currently we're seeing those challenges very much front and center in Slovakia, despite the fact that Slovakia had transposed the directive and had prior provisions, including the very important aspect of the special whistleblower status, which is a very important aspect and in a way very reflection of a best practice internationally that Slovakia has had, which is actually currently being challenged by the new government there. So the first aspect in terms of what the role of the Commission is, and it's, as I say, ongoing, is to see these two aspects of it. What can the Commission actually do if these aspects are not being complied with? Well, we in European law, sort of the treaties, call the Commission the guardian of the treaties and the guardian of European law, because it has a big discretion in making sure that through the infringement procedure, member states are held liable for non-compliant with European law. And the Commission, I'm actually been in a way pleasantly surprised that has shown very serious effort in actually making sure that it is taking its role as a guardian seriously, because we already see 6 procedures refer to the Court of Justice. And before that, the Commission had sent letters to each member state that had not complied with the implementation on time. So in short here, it is important to say that there is evidence to suggest that the Commission is taking the compliance seriously. And that is very good in of itself, because if I look at comparatively with other EU law directives, there tends to be a delay in transposition on average for 1 year. There tends to be sort of obviously missteps or lack of proper application. But in this case, we're seeing the Commission make sure that the whistleblower protection is put forward. Now, I want to move a bit beyond and expand our view in terms of what does the institution as the Commission can do, and what maybe we across as individuals within the remits of European law in terms of enforcing can do. And that is that actually through either individual complaints to the Commission, to ask the Commission to bring infringement procedures, of which we already have an example from Germany, and I guess we will hear that a bit more in a few moments. That's very important, but also the fact that if individuals can actually, through domestic courts, bring cases in holding, and I want to be clear, this is not a matter of being a whistleblower and sort of not being able to call upon that legislation, but even holding member state liable for lack of compliance with EU law starting through domestic courts, essentially. That too is possible, as well as holding specific institutions of member states liable for lack of proper compliance. And lastly, in terms of the enforcement part, the Commission has an obligation itself next year to report to the European Parliament how the transposition has been working, how the implementation is going, because potentially it is also viewed within the directive as a moment for potentially expanding or revising the directive. There will be parliamentary elections at the European Parliament next year. And in that sense, I am not very confident to say that there will actually be an expansion or new rights. Hopefully, there will not be a regression at the EU level itself, but it will be an important moment for the Commission also to represent data from across the member states. And in terms of where member states are now, and I think in terms of Commission's monitoring, the Commission has actually been continuously in contact with different member states and trying to sort of steer the process of enforcement or rather compliance stage at this point, and then helping in the getting it right, so to speak. I hope I'm not beyond my 10 minutes. I will pause here, but I'm very much looking forward to your questions, where I hope I can delve even in more detail in the specific legal instruments at the EU level and national level potentially, and combined to enforce this directive. Thank you very much again.
Thank you so much, Vigilenza. Was particularly interested to hear you mention the non-regression clause. Around the time when we first heard from our partners in Ireland and in Sweden, actually, that they were concerned transposition was going to be used to water down the protection already afforded to whistleblowers. We did a survey of our country editors for the Monitor, and actually in all 11 countries which already had some form of protection, there were concerns that the new laws would actually restrict those rights. So it's something that all of us who are in this field should be cognizant of and aware as we move forward. But perhaps we'll save that for the question and answers. Thank you very much indeed. So we turn now to Dr. Simon Gerdemann. Simon, the floor is yours.
Thank you so much, Ida, and thank you so much, Vigilenza. I'm going to pick up right where Vigilenza left it and talk about the consequences of failures of transposition. So we've already, and it's a bit more particularly what you can do about it in your country probably. We've already heard that the guardian of the treaties and the guardian of the transposing the directive is the Commission. So the Commission will actually and is currently checking the conformity of the transposition laws with the directive. The problem for you is, or the problem for anyone who is working for an NGO or is interested in protecting whistleblowers, there isn't much you can do to directly influence the Commission's work and enforce the Commission to actually enforce the directive and see if there's actually conformity with the requirements of the directive. There's one thing, and it's probably the best way to actually, get into the Commission's ear is writing a formal complaint, which is what Cosmas Zittel did for the whistleblower network, and that's really something you can't really force the Commission to do anything, but you can, make the Commission aware of transposition failures in their country. So the Commission itself is currently checking whether those laws are actually in conformity, but you may actually, help them see a couple of aspects that maybe they're the people who are responsible for checking the conformity for the specific countries missed, or maybe reinforce some of the points that those people responsible for those countries have already pointed out to the Commission, and then we'll probably be subject to a further infringement proceeding. Now, those are rather informal, even though it's a formal complaint, those are rather informal methods to hope to influence the transposition of the directive. What can you do inside your country if you see that there are some aspects of your national transposition law which are not in compliance with the directive? And the best thing you actually can do is, and Vigilenza already talked about this, is try to enforce the directive via the courts. So what you could actually do is either be a party of a legal proceeding yourself, or engage in strategic litigation, which is what, for example, NGOs in Germany are doing, the GFF, the Gesellschaft für Freiheitsrechte. Those are actually, trying to find cases where people are filing a complaint which actually has something to do with the directive not being transposed sufficiently, and they will fund those kind of proceedings, and they will support those kind of proceedings, and hopefully get them up all to the ECJ, to the European Court of Justice, because that's what judges have to do in the national legal orders if they believe that something is not compliant with the directive, and they want the European Court of Justice to help them interpret a certain provision of a directive. They can send it up immediately up to the ECJ, and the ECJ will then issue a verdict on the matter. Now, more specifically, when we're talking about non-compliance with directives, what is the consequences and how can national courts actually enforce European law if the national transposition law is substandard? So the first thing that courts have to do by means of European law is to interpret national provisions, national transposition laws in conformity with the directive. So they have to do everything that is permitted within their legal order, within their way of interpreting statutes within their own country, to actually interpret it in a way to conform with the European requirements. I'm going to give you an example of what happened in Germany, for example, so you can see how these issues sometimes unfold. The directive is quite clear on the fact that whistleblowers who have been subject to retaliation have to receive immaterial damages, or damages for pain and suffering, basically, for psychological damages, if you will. That is something in Germany which wasn't in the original draft of the government for the new whistleblowing law. We then had expert hearings, 2 expert hearings in the parliament, where we pointed out, you know, guys, this is actually missing. This is required by European law. You should, you know, have a provision which explicitly says you can get damages for pain and suffering, which under German law you usually only get if that's explicitly mentioned in the law. You don't get it by default. We were successful in getting the legislators to write such a provision into the new law, and we're all very happy that we achieved that. The problem then was, however, that the legislator, the 3 parties which are now forming the government, had to find an agreement with the opposition, which is now currently holding the majority in the 2nd chamber of legislation, and they had to, you know, make a compromise, you know, offer them something, because they were not really keen on whistleblower protection. They were more keen on protecting companies from whistleblowers. And one of the things they offered as a compromise is, you know, guys, how about we just strike out this provision for pain and suffering, for immaterial damages? Why don't you just get rid of this? And then we have something that decreases the protection of whistleblowers and increases the protection of the companies, and we're all fine, and you're going to give us something else in return. And that's exactly what they did. And now in the final law, the German law doesn't explicitly state that you can have damages for pain and suffering, which means that generally you won't get damages for pain and suffering as a whistleblower. Now, the first thing you can do, as I said, is interpret the national law in conformity with the European requirements. The problem is that the courts generally have to apply the national rules of interpreting laws, and it's very hard to interpret a national law in a way that explicitly the legislator didn't want. So if the legislator explicitly struck out a provision of the law, you can't really say, well, now we're going to interpret it in a way that they actually meant that this should be in there. So probably that's not really going to help us all that much. And you will encounter similar situations with your national transposition laws as well. So what's the next thing you could do? What's the next thing you could tell judges, either in strategic litigation or when you're an actual party of litigation, of a court proceeding? Well, the next thing you can say is, well, the directive isn't transposed correctly, but it has direct effects on the national legal order. That is something that's actually possible under European law. So you can have the directly affecting, you know, requirements of a directive, and people who are within a legal proceeding can actually say, well, I can't really call upon the national law to help my cause, to further my cause, but I can directly call upon the European directive and, you know, draw rights from that. The problem there, again, is it doesn't apply to all cases. Those direct effects generally are only possible if you're in a so-called vertical relationship, which means that if you are suing the state, then you can actually rely on the directive and parts of the directive that hadn't been transposed. If you're actually talking about a so-called horizontal relationship, which means you against your employer, 2 private parties, then those direct effects doctrines don't work, because the court basically said neither of those private parties is at fault for not transposing the directive. Neither of those parties could know what the directive said, because you only have to look at your national law, so it doesn't apply to you guys. So you could use that direct effects doctrine in your national laws, but only if you're suing the state, for example, if a civil servant is suing the state because they've been subject to retaliation. So that would be your option. Now, what if you have, and that's the last thing I'm going to say about that, what if you find yourself in a situation where you're trying to sue your employer for damages, for example, just in our case. You can't sue them under your national law. You can't rely on direct effects because your employer is a private entity as well. What's the last thing you can do? The last thing you can do is you can say, well, this directive is overlaid by primary law, which means the original agreements, the original provisions of the European Union, and therefore it can apply directly. What does that mean? Primary law are, for example, human rights, as laid down in the Charter of the European Charter of Human Rights. And if you can say, well, there are parts of this directive which are actually just, specifying things which are also already guaranteed as human rights on a primary law level, then you can apply those things directly in national court, because primary law, those primary human rights, actually apply directly in court. The problem with that is that this is quite a new doctrine that the ECJ came up with a couple of years ago, and it's not quite sure whether it applies to every kind of primary law and every kind of human right. It does apply to some human rights, discrimination, related human rights, for example. It doesn't apply to others, and the court hasn't yet decided whether it applies to freedom of speech, which would be the human right you want to rely on when you're talking about whistleblower protection. There is a strong case to be made, and you should make it in national court, that actually freedom of speech human rights are actually those kind of human rights which can, be primary law that overlays directives, and therefore you can rely on those provisions in the directive which support freedom of speech, such as whistleblower protections, directly. However, that's going to be a long legal battle, because you can be sure that's going to go up to the European Court of Human Rights, and they have to decide upon it, and then we just all can hope and pray that they actually decide that freedom of speech is one of those human rights which actually can be directly called upon in national court. If they do that, then that would be a huge win for whistleblower protection in Europe, because then we could basically, rely on every provision, every requirement in the directive, always say, this is just specifying the human right of freedom of speech, which can be relied upon directly. And then we don't really have to care about, insufficient transposition laws anymore. We'll see if that's going to happen, if we find a case that we can strategically litigate and actually bring up to the ECJ, but that's what the future years will have to show. So I know that was a lot of input and a lot of technicalities and legal stuff, especially for those of you who are not lawyers. What is the main takeaway I want you to have here is, if you find things in your national laws which are not compliant with the directives requirement, then there are actually ways to, enforce that as a private party. One way is that you actually ask the Commission in a formal complaint. They don't have to follow your complaint. They don't have to tell you anything, but you may influence the Commission for infringement proceedings regardless. The second way is if you find a case, if you strategically litigate a case, or if you're actually involved in a case which raises the question of conformity with the directive, and then you actually have to, basically shoot from all barrels, try to interpret it in conformity, direct effects, ask your European lawyer, the European lawyer of your favor, which you trust, and maybe even rely on primary law. And then hopefully you will actually get the national courts to either decide, we're actually gonna, amend these problems with our national law, or we're gonna send it right up to the European Court of Justice, and they're gonna, have a ruling which will, in effect at least, then be applicable in every member state. In effect, not technically, but still. Okay, that's it from me. I hope it wasn't too much, and I'm looking very much forward to your questions after we've finished our presentations. Thank you so much.
Thank you so much, Simon. That was very interesting. I think there will be a lot of very interesting strategic litigation to come. I've already had quite a lot of interest and questions from our partners in Europe asking about what more can be done to challenge the transposition failures, as we've called them today. Turning now to Marie Terracol, who will talk to us through the new report that TI have published, looking at EU minimum standards and best practice. Marie, the floor is yours.
Hello, thank you very much for allowing me to present Transparency International new report on how well EU countries protect whistleblowers. as many of you probably know already, Transparency International has been working to improve the protection of whistleblowers in Europe for over 10 years, both in member states and at the EU level. We were a long-time advocate of an EU directive on whistleblower protection, and we're very involved in the process of its adoption, advocating to ensure it is in line with best practice. So of course, we followed closely the transposition of the EU directive by member states. We raised concerns about the delays and the transparency and inclusiveness of the process in some member states. And now we are looking at the whistleblower protection laws of 20 of the 25 EU member states that have actually adopted whistleblower protection laws to transpose the directive. So we looked at 9 key aspects of whistleblower protection. 4 of them are requirements of the EU Whistleblower Protection Directive that we find very important, that we advocated strongly to make sure it is part of the directive, because it was not in the original drafts, and 5 areas where the directive has set a minimum requirement that falls short of best practice, but at the same time expressly allows or even press member states to set higher standards. So now I just would like to maybe look a little bit deeper in maybe not all, but some of those key areas. But before that, just maybe the main findings. We were very concerned to find that 19 of the 20 countries that we reviewed actually do not meet the requirement of the directive in at least one of the 4 key areas that are covered by the paper. So it's only 4 areas of the directive. So, well, I'm not sure what it means for the rest of the directive. And while we were encouraged to find that many member states have chosen to adopt provision that provides stronger protection for whistleblowers than the minimum standards of the directive, none of the 20 countries reviewed have chosen higher standards in each instance where the directive specifically offered this option. So in the 5 cases we reviewed. So now, maybe looking a little bit more deeper at some of those key areas, and the first one is the material scope, because it is a crucial element of whistleblower protection, because it determines what type of wrongdoing falls under the laws. That means what kind of information a whistleblower can report to benefit from the protection of the law, and which will trigger a response from the organization or the authority that receives that report. So a whistleblower protection law that follows best practice in every other aspect, but has a limited scope, will be quite ineffective, because it will only apply to a handful of specific situations. So as you know, the directive itself has limited and fragmented scopes for a number of reasons, but at the same time, it expressly allows member states to choose a wider scope. And the European Commission have been pushing member states to do that. But unfortunately, only 8 member states of the 20 reviewed have adopted legislation with comprehensive and consistent material scope. You can see them on the map. While the other 12 countries have adopted legislation with either fragmented or limited scope to various extents. I mean, we're talking very, very limited scope in some countries, just to the level of the directive, for example, in Greece, and to others that actually have like a much wider scope, but somewhat fragmented. For example, in Germany or in the Czech Republic. So, I mean, we are concerned that this will create many implementation challenges for whistleblowers, but also for public institutions and company and competent authorities and judges, and I mean civil society organization that will be asked to advise whistleblowers, for example. So we will need to follow this quite closely. Two aspects that we look at as well, because they are really key to enforce whistleblower protection, are the remedies for whistleblowers when they suffer retaliation, and penalties for violation of whistleblower protection. So here we're looking at key areas where that are mandatory according to the directive. And we found that only 7 of the 20 country whistleblower protection law that we reviewed, 7 of them do not ensure that whistleblowers receive full compensation for the damage they suffer. So this is a really concerning here. And we also found that only 12 countries have established in their whistleblower protection law penalties sanctioning the 4 types of violation of whistleblower protection. So here we're talking retaliation, of course, but also vexatious proceedings against whistleblowers. So when they're being sued for libel, for example, or defamation, when they're being prosecuted, when there is an interference with whistleblowing, when someone tries to stop the whistleblowers from making their reports, and breach of confidentiality over the whistleblower's identity. All of those, the directive requires that member states actually sanctions those wrongdoings. And so, as I said, only 12 countries have established penalties to sanction this violation in their whistleblower protection laws. But at the same time, in contrast, 19 of those 20 countries, their whistleblower protection law established penalties for knowingly reporting false information. And in 3 countries, the penalties for knowingly reporting false information are even significantly higher than those provided for some of the violation of whistleblower protection. So this actually sends the message that dissuading knowingly false reporting is more important than dissuading wrongdoing against whistleblowers. In the study, we also looked at the issue of anonymous reports. So the directive does not make it mandatory for competent authorities and organization to accept and follow up on anonymous reports. It leaves it to member states to decide in this area, and we found that, well, half of the countries require their competent authorities to accept and follow up on anonymous reports, and 9 require public and private organizations to do that. So less than half, and we find it's a missed opportunity, because welcoming anonymous reports really help build trust in whistleblowing systems, and it tells potential whistleblowers and other stakeholders that addressing wrongdoing is more important than identifying who is blowing the whistle. And it encourages people to speak by enabling them, like those individuals who would not speak otherwise because they fear retaliation or that insufficient care will be taken to protect their identity. And anonymous reports do provide valuable information about wrongdoing that puts an organization or the public interest at risk. So yes, as I said, a missed opportunity here. Finally, as I said, so we looked at also 2 other areas where the like mandatory areas of the directive, and we found that 4 EU countries failed to allow whistleblowers to report wrongdoing directly to the authorities without any restrictions. So here it's Italy, Lithuania, Portugal, and Slovenia. And it is quite surprising, because it is very, very clear in the directive that they should be allowed to do that. And again, that's an area that's been really at the heart of our advocacy, and of also a lot of MEPs were behind this provision. So and the vast majority of EU countries require 1 or more authority to provide advice to whistleblowers for free and easily accessible advice. So that's actually good news, but in some instances it's quite vague in the law in general. So we'll have to see, once maybe there is a little bit more through regulation, for example, to see how it's going to work in practice. And finally, So I had said 5 areas looking at best practice, and here we found that basically half of the countries make it mandatory for public entity to establish whistleblowing systems. So for all of them, like the directive had some exceptions for smaller municipalities and smaller public institutions. Most of the country, a vast majority, provides penalty for failure to meet obligation on internal whistleblowing system, and we find that's very good news to make sure that organizations actually do, fulfill their obligation. I will have to see how this is actually enforced in practice. And also a majority of member states includes, like, the laws provide for legal or financial supports for whistleblowers, which is also something we find key to make sure that, well, whistleblowers know about their rights and know about how to enforce them. So yes, I think I will leave it here, and happy to take any questions. Thank you.
Marie, if you stop sharing, thank you very much. And we will move on, hopefully come back to Marie shortly, to Susanna, who is the Vice Chair of the Network of European Integrity and Whistleblowing Authorities, to talk about the enhanced role of competent authorities. Thank you, Susanna, the floor is yours.
Thank you, Ida. Thank you for the invitation and this really interesting event. And it's great to hear that there are so many, and see that there are so many people caring about the proper transposition. And as Anna has said very correctly, that the transposition is just the beginning of the new story. And I might add, on behalf of Slovakia, as the leader of the few organizations that have a central role, and they are independent authority in the agenda of whistleblowing, that it's not only that because what we are seeing and experiencing now in Slovakia, that despite having quite progressive law and quite developed, that maybe serves also as an inspiration for other countries, it's not a done deal. It can change at any moment with a change of political situation, and sometimes the impetus might be quite not obvious. It's probably the agenda behind changing the law might be completely different, but the consequences on the standards of whistleblower protection might be devastating in some aspects. So this is what we are dealing now in Slovakia, and maybe later on when the story is over, or when we see the results, there will be a possibility to share that. But today, as I've understood, I've been invited to speak on behalf of NEVA. So I'd like to share a little bit of story of NEVA, although I am not a founding member of NEVA because I've joined only 2021 when the Whistleblower Protection Office in Slovakia started. But anyway, I have some sharing of information of my colleagues that have been there from the very beginning, and I'm happy that I see a few faces from NEVA as well joining us. So I'll share my screen as well because I have a few slides prepared. So just checking whether this will be working. Is it okay? Can you see it?
We can see perfectly.
Yes, you may want to
Great.
press present mode.
Okay, thank you. So how it all started. NEVA was established in May 2019 at a meeting in Hague, and it was not imitated by the Dutch Whistleblowing Authority. As you see, it's a clear typo there. It was initiated by Wilbert Thomason, who was the leader of the Dutch Whistleblowing Authority, and they started the initiative to joining forces of existing authorities around Europe in reaction to passing of the European directive. So it has step by step become a platform to exchange knowledge and experiences and ideas both in practical and strategic level. You see the picture of the first meeting, and it were initially 8 authorities. And you can see that in March 2023, when we had the last plenary session, there were much more people there sitting. So we grew up into a bigger bunch of people and organization. Currently, NEVA has 33 members, so 33 authorities in the area of whistleblowing and integrity, based in 22 countries. So there are several authorities on behalf of certain countries where there is a federal organization of country, or there are several authorities. So why NEVA? What it means, NEVA? NEVA is a network of practitioners. And what is important to understand that we are an organization of state authorities. So this is not an organization containing a membership on the side of civil society organization, but central authorities that meet and share experiences from actually exercising the law, which is a good practical contribution. And we are happy to partner with NGOs and other state authorities. So this is our specific characteristic. So we share knowledge and try to fuel effective application of the directive, and also trying to serve as a collaboration hub for the future. And as you understand, and as I started telling the story about NEVA in May 2019, we started to focus on the transposition, proper transposition, or at least some transposition of the directive. And step by step, we directed and our activities towards understanding each other, towards monitoring our activities, toward understanding how actually, when step by step the transposition has been done in individual member states, how actually individual member state went about the transposition and how organized are our central authorities. So understanding even our own competencies. And as we have done this monitoring, you can see there that individual member states deal with the agenda and with administering the agenda differently. You see that there are independent anti-corruption authorities in the first column. Then many organizations integrated that into an agenda of ombudsperson authority or part of central government, which might be challenging slightly in terms of independence. And then there are a few independent authorities, as you can see, Netherlands and Slovakia, or other types of authority like personal data protection offices, or even the prosecutor general, as you can see in Lithuania. And firstly, we went deeper into our competencies of a network. And there you can see a nice chart where you see that also our authorities, individual member states authorities, deal with the agenda of whistleblowing differently, and we combine different kind of competencies and activities. So we grouped all those competencies and activities into 4 different areas. You see on the left side, the prevention and education and awareness raising, cooperation with civil society, and then the advice for whistleblowings, advisory function, even for employers, issuing guidelines and manuals in the agenda. So basically caring about the infrastructure of whistleblowing in member states. And then, of course, the core business of the majority of the organization, as you see the percentage of activities, is about reports, collecting, receiving reports, and an investigation of the actual whistleblowing reports, or receiving retaliation reports, and then investigation, as well imposing sanctions. And then the other area which you see that it's very little represented is kind of a psychological support, that it's increasingly called by many individual whistleblowers that it's very important agenda. We recently had a conference in Slovakia with few represented whistleblowers, and they all echoed the need for kind of like broader support not only the legal one, but also the broader one, especially emotional, psychological protection, or any kind of coaching in the area of finding a new job, etc. So you see you see the structure, how the majority of member states go about, and what we try to do now as we move forward from the transposition monitoring towards the actual implementation. We decided, as we grow in number and activities, that we will establish working groups to summarize more concretely and very practically our practices, our best practices, and to point out the challenges in application of the directive. So we established this year at the beginning whistleblower support group and whistleblower report group, where we monitor we are currently in the midst of our work, whereas in the first group we monitor how to listen and to talk with whistleblowers, how to recognize what is the characteristic of a whistleblower in individual countries, how we navigate whistleblowers, how we accompany, what kind of support we provide. So everything which turns around the whistleblower support. And in this working group, we share our concrete experiences, share our legal regulation, and then it should turn into a summary of best practices that we are ready to share also to other stakeholders. So this is the plan for the next year. So I hope you might then later on hear from us. And then as it comes to whistleblowing reports group, this is all about procedural type of activities. So how we provide channels, what is a technical solution for receiving whistleblower reports? What about anonymous reporting? How do we investigate whistleblowing reports or retaliation reports? And what is the follow-up? So all the practical details, where we also collect data from individual member states, and then we plan to summarize that. So this is from me for the moment, I think all, and I'm ready to answer your question, be it on behalf of Slovakia or Neva. Thank you a lot.
Thank you very much, Susanna. We've been very interested to see the development of the network and some of the sharing of best practice of some of its members, as well as pleased to see the recommendations for responsible transposition coming from some of the declarations of the network as well. I have some questions. I'll save them for the session at the end as we turn to our next speaker. We've heard so far about the oversight and enforcement of the directive at the EU level, the legal consequences for transposition failures. We've looked at some of the transposition laws, what they look like, whether they meet the minimum standards, as well as the role of the competent authorities. Next, we will hear from our speaker from Germany, who, as Simon mentioned, has been involved in submitting an official complaint to the Commission on the German transposition law, which we're very interested to hear about. Cosmas, if you would join us, the floor is yours. Thank you.
Yeah, thank you very much for the invitation. Yes, as you mentioned, my name is Cosmas. I'm from Whistleblower Network, which is a German NGO which closely accompanied the legislative process for German whistleblowing law. And it was a process that took quite long. And when you look at the result, you actually wonder why. Because if you put it a bit simply, the law only goes beyond the minimum requirements of the directive in one place, and that's the material scope. This was extended to all criminal offenses and certain administrative offenses. And yeah, you have to say anything else would have been completely impractical. So why did it take so long? Well, business associations strongly opposed any whistleblowing law, and their complaints fell on receptive ears, particularly among the Christian Democrats. And German federal system made it quite easy for the Christian Democrats to block the law for a long time, because it does not only has to be approved by the Bundestag, the national parliament, but also by the Bundesrat, which were the representatives of the federal states, or where the federal states represented. And the Christian Democrats were first part of the national government, and then later on they had the majority in the Bundesrat, and that's made it very easy to block the law for a long time. But finally, Germany did it, and since 2nd of July, we have a whistleblowing protection law in Germany, and we finally implemented the directive. Or have we? Not really, because the German law fell short of the requirements of the European Union, as Simon already mentioned. And that's actually quite good news, because we were not too happy with the law. There were many points we were not happy about it, where we expected more than the law actually did. But if you look at this very complicated process, you see that's very unlikely that the German government or the German parliament will make any changes to the law, because this would mean that the whole process starts again. But, and that's what we hope for, is that the European Union will force Germany to do that, because the law is not compliant with the directive. And to ensure that the European Commission really does that, we submitted this complaint there. But what do we mean by complaint? I mean, you can complain about a lot of things, and normally you don't get any answer in politics, or a pretty meaningless answer. But in this case, this is not that easy, because complaining to the European Commission that's an official procedure. Anyone who believes that a member state or one of its authorities is in breach of European Union law, or one of its practices is against European Union law, can submit such a complaint, and it's a standardized procedure. There's a standard complaint form where you have to explain why you think the European Union is breaching it. There's certain questions you have to answer. You don't have to write too much, or you're not allowed to write too much. You're explaining that, and that's what we did. Well, basically, that's what our chair, Annegret Falter, did for us. She submitted 13 complaints to the European Commission. We got a confirmation of receipt within 15 working days. We're still waiting for the first assessment by the European Commission. Then the European Commission has another 12 months, or normally another 12 months, to make a proper, thorough assessment. And if it comes to the conclusion that there might be infringement, it will ask the member state for its view on that. And after that, it might ask the member state to bring the infringement to an end within a certain period. And if that doesn't help, the European Commission could go to court, to the European Court of Justice, which would be especially embarrassing for Germany, because there is already a infringement feature going on before the ECJ. Well, as I said, we've identified, or we submitted 13 complaints. I cannot explain all of them. But so I will limit myself to those that are particularly relevant to our main points of criticism of the law. You can see we are particularly hoping for improvements if it comes to, here it's marked at green, if it comes to compensation, and those marked in orange, that's where we hope at least for some improvements. Yes. And as you can see, or as Simon already mentioned, where the law particularly falls short of the requirements if it comes to compensation. Well, the directive prescribes full compensation for all damages suffered, while the German law only or the German compensation in the law, the compensation in the German law is limited to compensation for financial losses suffered. What is completely missing is compensation for intangible damages, such as pain and suffering. And we all know how much stress and pressure whistleblowers in Germany whistleblowers generally are, and that should be compensated. The directive also says that in its recitals, that there should be compensation for that. The second problem is that for many whistleblowers, reporting means basically the end of their careers, or at least the break of their careers, because their contracts are not extended, or they denied a promotion, etc., etc. And the German law explicitly says, well, even if you suffer from such reprisals, you are not entitled for an employment relationship or a career advancement or anything else you would have gotten without your whistleblowing. And again, we think this is, if you look at the recitals of the directive, this is not in line with the directive. So overall, we can say Germany's law doesn't fulfills the requirement of full compensation of damages suffered, and therefore is in breach of the directive. Well, another aspect we think where we think there should be changes, or where the German law is not in line with the directive, is if it comes to follow-up measures. As we all know, whistleblowers want to achieve changes, and they're looking for the best way to achieve them. And this is why it's so important that the directive clearly says or defines how an external reporting office has to react on the report. This includes certain follow-up measures and also includes giving feedback to the whistleblower about the progress of the report. But it is often the case that the external reporting offices have neither the expertise nor the resources for proper investigation. So it's quite okay that they forward or transfer the investigation to another authority which has the expertise. That's completely in line with the directive. But what is not in line with the directive is that forwarding such a report means that the external offices are released from further responsibility. For them, the case is closed. They do not have to ensure that an investigation is taking place, nor do they have to ensure that the whistleblower gets any feedback on what is happening about the misconduct he reported. So the further proceedings might become a black box for the whistleblower again. And we know that from other countries and from studies that this is something that will discourage whistleblowers from using those external channels. In addition, this incomplete interpretation of follow-up leads to follow-up problems, because according to law, disclosures are allowed when no appropriate follow-up action has been taken. But if you limit follow-up action to just forwarding the report to another authority, it's quite easy. That's something the external reporting office would have to be very dysfunctional if it's not able to do that. So there will be rare cases where a whistleblower can rely on that provision to make disclosure. That's the same as the case if you complain. It's the same is the case if it comes to collusion between the external reporting office and the perpetrator, because this would be another justification for public disclosure, but this will be rarely the case. What might be more often the case is that there's a collusion between the perpetrator and the supervisor authority, and the external reporting office might ask the supervisor authority to look into the case, to look into the report. But in that case, public disclosure is not allowed by the law. So if you look at it, no proper follow-up messages, no, it's not ensured that there will be any feedback to the whistleblower. That will mean he will be discouraged from external whistleblowing. This is something we find in other parts of the law as well. And for example, if you report internally, the law says you have to wait until the internal investigation is finished before you can go to an external reporting agency. Or it says disclosure of incorrect information is prohibited. So if you, and we all know a whistleblower cannot 100% guarantee that what he's reporting is right. It should be enough if he has reasonable grounds to believe, as it says in the directive. So this is not sure whether these two criticisms have any illegal implications, because you can interpret them in a way that is in line with the directive, but it will confuse whistleblowers and it might discourage them from doing external reporting or from disclosure, which is, as we think, not in line with the directive. Yeah, to conclude, the German whistleblowing law, it's a progress for whistleblower protection in Germany, but it has a number of shortcomings, and it will be very difficult to address the shortcomings because making any changes to the law is so complicated in Germany. So once again, we have to rely on the European Union to help us to make a better whistleblowing law in Germany. And yeah, submitting a complaint gives us is a way to contribute to that, and we will keep you posted on that, how that goes. Thank you.
Thank you so much, Cosmas. We have had many questions about how and why you submitted this complaint, and with others presumably looking for inspiration as an option to challenge their own laws. So thank you for taking us through the complaint. That's much appreciated. We'll turn now from Germany to Czech Republic, where we have Jan Dupak presenting on some of the recent cases that have been coming through already, looking to seek protection under the new transposition law. Jan, the floor is yours. Thank you.
Thank you very much. We are moving to another country, but at the moment I feel I could say almost the same introduction as Cosmas did, because we had the same procedure when the law was advocated for, and we were part of that. Because after a long time, we moved to a law which actually is not interesting in any special way, because it's just transposition of the necessary parts of the directive. Maybe the only difference is that we are not surprised it's so late, because we are usually late in implementing European directives. But at the end, we got a law on whistleblowing with an accompanying law in June this year, coming into effect on August 1st this year. As I mentioned, the law is not very interesting if you are comparing it with other countries, because generally it's just a translation of the directive with few problems that we see there. The first one is this wide and fragmented material scope, which goes further than the directive actually forces us to go, but it's so fragmented and it's so complicated that it will be actually an obstacle for blowing the whistle in practice. Although it's quite wide, so at the moment we are okay with this compromise of the material scope in force. The other point is that the anonymous reporting is not allowed, which is, in our opinion, this regression, because before this law came into force, we had just a government regulation regarding the state authorities, which actually forced all the state authorities to receive anonymous reports. So now we are arguing that this is a step back in reality. The third problem is the external channel for reporting and the responsible authority, which has been, which is the Ministry of Justice. And I will get to that because one of the cases that I'm going to present is at the Ministry of Justice, as we were anticipating from the beginning. But I will talk about several cases which are interesting in our opinion, because we are already testing the new law. And in the first case, it's actually testing the direct effect of the directive, because this happened before the law came into force. But it's a case from this year. And in this case, we already have the final judgment of a court. So it's interesting from that point of view. In these cases that I'm presenting, I'm not going into detail because of the limited time I have for the presentation. But if you have any questions, feel free to ask. I will be happy to answer. And I put pieces of the news in the presentation, and you can check it in the articles. Unfortunately, only in Czech, but I guess nowadays it's easy to translate everything. So the first case is case of Mr. Pavel Kodim, who used to be the director of the Central Independent Authority, which is a Transport Infrastructure Access Authority. Nobody knows about the authority. It's very small, with 20 people, and focused on really narrow field of transport infrastructure. But all the EU states have to have some independent authority. It can be joined with other authorities, but in the Czech Republic it was a standalone authority. This was a former director who was supposed to be appointed for the next term, but on the day when he was supposed to be appointed by the government for the next term, he received a phone call from the Minister of Transportation asking him if he sent a report to the European Commission asking about one of the cases, which is actually very sensitive and regarding a lot of money, which influences the budget of Czech Railways directed by the Ministry of Transportation. So obvious conflict of interest, in my opinion. Pavel Kodim replied that he did send a letter. Next day, on the same day, within an hour, the proposal for his appointment was withdrawn by the Ministry of Transportation. And the next day, the proposal to abolish the whole authority was proposed, and it was actually accepted by the government. Mr. Kodim fought this decision at the court, and the court decided. The decision is from February this year, and a law on abolition of the transport infrastructure Transport Infrastructure Access Authority has passed the parliament and will be signed by the president soon, I guess. So it's going to be effective starting January 1st next year, and the whole authority will merge with anti-monopoly office. And Mr. Kodim fought the decision at the court, and the court decided in November this year that this step was actually a retaliation against a whistleblower, and ordered the government to discuss the matter again, it ordered the Minister of Transportation to bring the proposal to appoint the director of the authority again to the session of the government. The problem is the session of the government takes place next week, and the authority is going to be abolished on January 1st. So we probably all know what the result will be, but at least we have a final decision of an administrative court, which actually decided quite quickly because it was an urgent matter, which actually used the whistleblowing directive as an argument for abolishing a decision of the government. So it's a very interesting case, in my opinion, because and it also got a lot of media attention. The person of this picture is the Minister of Transportation, just to make clear. And the next case, which actually emerged at the same time in November this year, so recently, is the case from the Ministry of Justice. These two are cases which actually got a lot of media attention and were discussed together in many pieces on the news because they emerged at the same time. And this one is also interesting because Mr. Jan Benešík, who is on the picture, is a whistleblower at the Ministry of Justice, which is actually the whistleblowing authority in the Czech Republic. But Mr. Benešík is working as he currently still is working as a director of the Department for Insolvency Proceedings and the regulation of insolvency proceedings in Czech Republic. And he sent a report to another department of the Ministry of Justice, which is responsible for whistleblowing, that his supervisor, a deputy minister who is a political nominee, is forcing him to change the insolvency proceeding regulation in a way that favors insolvency or huge creditors. This supervisor is also the supervisor of the whistleblowing department at the Ministry of Justice, which is a problem. Apparently, Ministry of Justice changed that, so this political nominee is not in charge of this department of whistleblowing anymore, but still, he's a very close person to the minister. Mr. Benešík filed this report, and also this was published in the media. We are not, we don't have all the details about how it was published and when all the steps took place. So maybe there will be a question of public disclosure. And now we are obviously saying, we told you so, that the Ministry of Justice shouldn't be the central whistleblowing authority because it's a ministry run by a minister who is a political nominee, and there will be always a problem with independence. The problem, though, in the directive is that the directive wants the country to have an external channel, and the channel has to be independent, not the authority as such. So the channel, so they say that the Department of the Ministry of Justice is independent channel because they have their independent way how to receive reports, but the person at the ministry generally is not independent. There is a retaliation against this whistleblower because the minister decided or proposed to the government organization changes at the department, and coincidentally, the position of the director of the Department of Insolvency Proceeding has been divided into two other positions, and Mr. Benešík should lose his job on January 1st. He's going to the court with the case, so we will see the result, but we have a high-profile case, including a lot of interesting questions in implementation of this law. I have two more cases in the presentation, but they are much shorter, I would say. One of them is at the Ministry of Finance. This is actually the earliest case I encountered this year, which was a whistleblowing case. And this was Mr. Jíra, who filed a report that the Ministry of Finance is trying to make the audit reports of European funds to look better, or the results to look much better than they actually are. For example, this concerned the funding for fishery, which Czech Republic is a landlocked country, so it's like a saltwater, sweetwater fishery. But ministries were funding even projects for fish cultivation on places where there was no water, for example. And he reported that these audits are trying to make things better than they are. And apparently he's also about to lose his job on January 1st because of the same organization change that this government approved recently. So he's probably also going to fight at the court, so we will see how it goes. This case is interesting because I think that Mr. Jíra did everything he could to follow up on whistleblower protection laws and the directive. So he did all the steps as he's supposed to. So now we will see how successful he will be. And at the end, we have just an interesting case of an internal auditor who is actually not described as a whistleblower, but it's an internal auditor of the Ministry of Foreign Affairs, Mr. Čapek, and he did an audit report on HR department of the ministry, and he found serious problems there. But the HR department decided to let him go at the end of trial period because he didn't like the result of the report. He also fought at the court, but because it was the trial period, his position was very complicated, and he lost the case. But it brings an interesting question whether an internal auditor should be protected as a whistleblower or not, and if not, should every internal auditor report via the internal channel just to be safe, or how should he solve these cases? Because when he finds something problematic, what can he do? Because he's not a whistleblower, he's just doing his work. So this is another interesting question for us to check in the practice. I took it very quickly because in order to be quick, so I'm free to answer any questions if you are interested. Thank you.
Thank you so much, Jan, for outlining these very interesting cases in the Czech Republic. I'm sure there will be other very interesting cases coming through, and it clearly highlights that the law is not really where we want it to be in terms of protecting anyone that speaks up. So that concludes all of our presentations. We can move now for around 15 minutes of question and answers for our speakers. We already have one question in the chat for Simon or Dr. Gerdeman from someone who says, I'm currently working on whistleblowing for Turkey's legal context. Turkey is not a member of the EU, but is a member of the Council of Europe, and Article 95 of the Constitution blatantly gives precedence of international treaties over national law on the condition that they are relevant to human rights issues. The European Whistleblowing Directive aside, what does Simon think about the direct applicability of the European Convention on Human Rights invoking whistleblowing rights set out in the Guha judgment, that's a judgment from the European Court of Human Rights, and alike, or through the Turkish court justice system? I'm asking this in a way to accelerate Turkish authorities to adopt a whistleblowing law. Simon, would you have anything to say to this question?
Well, I can't say anything about Turkish law in particular, but it seems to me that the way that the European Convention of Human Rights is applicable in Turkey is similar to how it is applicable in other countries as well, and how the European Court of Human Rights actually requires the treaty states to apply those laws. And the question already referred to the Guya case. That was the first case that the European Court of Human Rights actually where the court set out its new whistleblowing rules. I would also look, if I were you, I would look into the second big case of the Grand Chamber, which was issued in January this year, which is the Halle case, which basically took Guya and then refined Guya a bit and actually made it easier in many whistleblowing cases to rely on the European Court of Human Rights judgments. Because they now accepted a couple of other categories which they didn't explicitly accept before to be protected under the European Convention of Human Rights. So as the question suggests, I would think that the European Court of Human Rights judgments will remain a very strong source of whistleblower protection, not only in Europe, but also in Turkey and all other states which are subject to the European Convention of Human Rights. We can talk about that later in more detail if you like, personally, but generally speaking, yes, look into the Guya cases, look into the Halle cases, and the court, maybe as a last little bit of information, the European Court of Human Rights has become increasingly eager that the national courts do not just fall below the minimum standard that the courts set up as a result, but also that they actually apply the criteria that the courts set forward. So that actually it's a 6-factor test for whistleblowing cases under the Halle and Guya line of judgments. And if you actually use them in front of court and tell the court, see, these are the 6 factors. This is what the European Court of Human Rights now says about these factors and how you should apply them, then I think you have a very fair chance that they will actually take those factors into account and make sure that you get the protection that you actually ought to get under the European Convention of Human Rights.
Thank you, Simon. Before I forget, I did promise that we would turn the recording off at this stage.